In this video, I will let you know if you can file a lawsuit against an officer or director of a company. I'm Santiago Cueto, board-certified international business law attorney and best-selling author. This is one of the most common questions I get from business owners and shareholders. The answer is more complicated than you might think. Let me start with what most people believe. Many think that corporate officers and board directors hide behind the company shield. They assume these individuals can never be held personally responsible. That belief is only partially correct. The law does provide protection to officers and directors. Now, this protection is called the corporate veil. The corporate veil exists for a good reason. It encourages people to serve in leadership positions without fear of losing their personal assets every time the company faces a lawsuit. But here's what you need to understand. That protection is not absolute. There are specific situations where you can pierce the corporate veil. And when that happens, officers and directors become personally liable for their actions. Now, let me explain when you can actually sue these individuals personally. The first situation involves fraud. If an officer or director commits fraud, they lose their corporate protection. This makes sense. The law will not protect someone who intentionally deceives others. Now, let's say a CFO knowingly provides false statements to investors. Those investors rely on those statements. They invest their money based on lies. When the truth comes out, those investors can sue the CFO personally. The corporate veil does not protect fraudulent behavior. The same applies to officers who make false representations in contracts. If they lie about the company's ability to perform, they face personal liability. The key word here is intentional. Mistakes are different from deliberate fraud. The second situation involves breaching fiduciary duties. Officers and directors owe duties to the company and its shareholders. These duties include the duty of care and the duty of loyalty. Now, the duty of care means making informed decisions. Directors must pay attention. They must review important documents. They cannot simply rubber stamp every document proposal. Now, the duty of loyalty means putting the company's interest first. Directors cannot use their position for personal gain. They cannot take corporate opportunities for themselves. When directors breach these duties, shareholders can file what's called a derivative lawsuit. This type of lawsuit allows shareholders to sue on behalf of the company. Now, if the lawsuit succeeds, the company recovers the damages, but the individual director or officer pays them. Now, here's where it gets interesting. Courts apply something called the business judgment rule. This rule provides significant protection to directors and officers. Understanding this rule is critical if you're thinking about suing. The business judgment rule creates a presumption. Courts presume that directors acted in good faith when making business decisions. They presume directors were informed. They presume directors acted in the best interest of the company. This means you cannot sue a director just because a business decision turned out badly. Bad outcomes do not equal liability. Directors are allowed to take risks. They are allowed to make decisions that don't work out. Let me give you an example of this. A board decides to expand into a new market. They review financial projections. They hire consultants. They debate the decision. Then they vote to proceed. The expansion fails and the company loses millions of dollars. Can shareholders sue the directors? Well, probably not. The business judgment rule protects them. They made an informed decision. They acted in good faith. The fact that it failed doesn't matter. But here's the key. The business judgment rule only applies when directors follow proper procedures. They must inform themselves before deciding. They must act without conflicts of interest. They must genuinely believe they're helping the company. If directors skip these steps, they lose their protection. Now, if they make decisions without reviewing any information, the rule doesn't apply. If they have personal financial interests that cloud their judgment, the rule doesn't apply. If they act in bad faith, the rule doesn't apply. This information can save you or your business significant money and legal headaches down the road. Now, if you're finding this valuable, take a second to hit that like button. Subscribe to my channel so you don't miss future videos that could protect your business interests. Now, the third situation involves personal guarantees. Sometimes officers sign documents in their personal capacity. This happens frequently with small businesses. A bank might require the CEO to personally guarantee a business loan. If the company defaults, the bank can pursue the CEO personally. The CEO signed in two capacities, one as an officer of the company and two as an individual guarantor. Many officers sign these guarantees without fully understanding what they're doing. They think they're just signing on behalf of the company. Read every document carefully before signing. Make sure you understand whether you're taking on personal liability. Now, the fourth situation involves commingling of funds. This is a major red flag. Officers and directors must keep personal and corporate finances completely separate. Using the corporate bank account to pay personal expenses is a big problem. Treating company money as your own piggy bank destroys the corporate veil. Courts will say you didn't respect the corporate form and therefore you don't get corporate protection. I've seen cases where officers wrote company checks for personal vacations. They paid their mortgage with company funds. They used a company credit card for personal shopping. All of these actions invite personal liability. Now, the fifth situation involves illegal activity. If an officer or director breaks the law, corporate protection vanishes. This seems obvious, but it's worth stating clearly. Environmental violations are a good example. If a director knowingly authorizes illegal dumping, they face personal liability. The corporate shield does not protect criminal behavior. Employment law violations work the same way. If an officer personally harasses an employee, that officer can be sued individually. The company might also face liability, but the corporate form does not shield the individual wrongdoer. Now, the sixth situation involves undercapitalization. This is more technical but equally important. Companies must maintain adequate capital to operate. If shareholders drain all the money from a company, they create a shell. When that shell causes harm, courts may impose personal liability. The reasoning is simple. You cannot create a company, strip it of all assets, and then use it to avoid responsibility. This often comes up in tort cases. Someone gets injured by the company's operations. They sue and win a judgment, but the company has no money to pay. The courts look at whether the shareholders deliberately undercapitalized the business. If yes, those shareholders may pay personally. All right, so what should you do if you're considering suing an officer or director? Well, first, consult with an experienced business attorney. These cases are complex. You need someone who understands corporate law and piercing the corporate veil. Your attorney will need to evaluate whether the business judgment rule applies. This analysis is sophisticated. It requires understanding exactly what the directors did and how they made their decisions. Second, gather your evidence. Document everything. Collect emails, financial records, and witness statements. The burden of proof is on you. You must show why the corporate veil should not apply. You must show why the business judgment rule should not protect them. And third, you need to understand the costs involved. These lawsuits are expensive. You're fighting against people who likely have resources and very good lawyers. Make sure your case is strong before proceeding. And fourth, consider alternative dispute resolution mechanisms. Sometimes mediation or arbitration provides a faster, cheaper path to recovery. Not every dispute needs to end up in court. And one more thing you should know. Some states provide more protections to officers and directors than others. Florida law, where I practice, has specific rules about director liabilities. Your state might be different. Also, many officers and directors have insurance. This insurance is called Directors and Officers Insurance, or a D&O insurance. This coverage can pay for damages even when personal liability exists. Your attorney should investigate whether such insurance exists. And finally, timing matters. Most claims have statute of limitations. Wait too long and you lose your right to sue. Act quickly when you discover any wrongdoing. The bottom line is this: you can sue officers and directors personally in specific circumstances. The corporate veil provides protection, but not absolute immunity. The business judgment rule adds another layer of protection for good faith business decisions. But fraud, breach of fiduciary duty, personal guarantees, commingling funds, illegal activity, and undercapitalization all create personal liability. Now, if you believe an officer or director wronged you, document everything and consult an attorney immediately. Don't wait until it's too late. Now, if this video helped you understand your rights, please like this video and subscribe to my channel for more legal advice that protects your business. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos here.